area around, we look at the word de facto and married and girlfriend, boyfriend, and how that affects things. How does, I mean, if we were to look at, whether someone is a de facto or a girlfriend or boyfriend, how might that affect my estate?
So basically there's two, the question of whether someone is a de facto wife or a de facto husband, which de facto in this context means a marriage-like relationship. So it's more than just a boyfriend or girlfriend. So this comes up in two main scenarios. One, whether someone's going to make a claim under the Family Provision Act, because to make a claim you have to be a family member, certain family members, like a brother or sister can't make a claim, only like spouses, which a married person, de jure spouse is the phrase for a properly married person, and a de facto spouse can make a claim. And so sometimes family members will say, nah, that was a girlfriend or a boyfriend, not a de facto husband or a de facto wife.
Right.
And if it's found to be that they're not in a de facto marriage, then they will not have standing or the ability to actually bring their claim under the Family Provision Act. The second, and I'll talk about what the test is in a minute, but the other time when this de facto issue comes up is in superannuation disputes. As I mentioned before, superannuation is not normally an asset for the deceased estate. So over here you've got your Family Provision Act claim stuff, and then you might have decisions of super fund trustees to pay out to certain people. And now a super fund can pay out to someone if they are a spouse, a de jure spouse, or a de facto spouse. They can also pay out to someone if they're classified as what they call an interdependent. And so often you will get people arguing whether the person was a girlfriend or boyfriend as opposed to a de facto, because that will determine whether they're eligible to receive superannuation and the life insurance components that are attached to those policies, which can be substantial, hundreds of thousands of dollars. Right. And there's no time limit on how long a person needs to be a de facto partner for the purposes of the Family Provision Act or the superannuation stuff. There are some rules about how long a person has to be a de facto if they're going to receive an inheritance under intestacy where someone doesn't have a will. So that's another area, like maybe a lot of the time there's no will, and then there's someone says, oh, I was a de facto, therefore I'm entitled, as a spouse would be entitled under the intestacy rules. And the family say, oh, no, you're a boyfriend or a girlfriend or whatever. So those are the three main ones. And the definition of a de facto, when someone's married, it's very easy to figure out whether they're married or not. You had a wedding, you got married, it's not rocket science. When you're a de facto, there is no actual marriage. So under the Interpretation Act, there is a set of like 13 or 14 or more criteria that constitute what is a de facto marriage, what's marriage like. One is the extent to which the people have a common residence, how they're known to family and friends, or known socially as a couple. Are they known as a couple?
So others will be consulted.
Yeah. Well, the evidence from other parties. Yeah. So family, friends. Did anyone know the aspects of their relationship, the public nature of their relationship?
Wow.
The extent to which they share finances is a really big tick item. So living together and the finances are the two big ones. That the case law says that not one element is determinative above the other, but in practice, like if you've got cohabitation and sharing finances, you're going to be ticking some serious boxes. The extent to which they have a sexual relationship, the extent to which they rely on each other for moral support and all of that. There's a list of a lot of things, and if you can tick those boxes, then you meet the criteria. So a lot of the litigation stuff is arguing whether they do or don't tick all those criteria.
Gotcha.